You're watching The Legal Breakdown. So Glenn, Jack Smith seems to be pulling no punches against Trump in this classified documents case down in Florida. He's been claiming, both in court and in public, that he had the right to take those classified documents home with him because they're his personal records. Can you talk about Jack Smith's response in court to that claim?
Yeah, Brian, Jack Smith, it seems, has run out of all patience for Donald Trump and the frivolous claims that continue to be made by his lawyers. It really is an embarrassment. Donald Trump can spew whatever he wants into the public square about the Presidential Records Act, letting him take some of our nation's most closely guarded secrets and declare that they are now his private and personal property. The problem is there's absolutely no legal support for that. So let me just read kind of the opening salvo from Jack Smith in this new court filing, because he does a nice job of summarizing and knocking down basically the three claims that Donald Trump's lawyers are trying to make now. He says on page 4, Trump's reliance on the Presidential Records Act as a basis for dismissing the indictment is wrong. The PRA does not exempt Trump from criminal law, entitle him to unilaterally declare highly classified presidential records to be his personal records, or shield him from criminal investigations, let alone allow him to obstruct a federal investigation with impunity. These claims should be rejected. So I can talk about really the primary claim Donald Trump and his lawyers are making. There are some that are a little sort of down in the criminal law weeds. They're a little weedy. And it has to do with the interplay between, for example, some of the civil procedures and remedies under the Presidential Records Act versus the criminal statute under the Espionage Act. And Donald Trump has been criminally charged for violating our nation's espionage laws, among other criminal charges. But here's Donald Trump's main claim. He basically says, any document or anything I take from the possession of the federal government, from the White House, when I leave federal service, is automatically converted into my personal records. And Jack Smith points out pretty directly and in an unvarnished way, that is BS. He doesn't use BS in the brief, but it really is absurd, the notion that any president, any government employee could take any of our nation's most closely held secrets, national defense information, military plans, contingency plans to, for example, attack other countries if it was in our national security, our national interest to do that. If a president takes them, they are automatically his, and he can do with them what he will. Can I use a quick analogy to kind of highlight just how absurd this claim is? So let's take on Donald Trump's favorite fever dream, that he could shoot somebody on Fifth Avenue. Now, he ordinarily says, I could shoot somebody on Fifth Avenue and not lose any votes. Let's tweak that fever dream just a little bit to highlight how absurd Donald Trump's claim is. So this would be like if somebody was down at Mar-a-Lago and they set foot on the front lawn of Mar-a-Lago, and Donald Trump didn't like that. He took out a gun and he shot the person dead, right? And then he told his lawyers, go into court and argue that I killed that man in self-defense. Ordinarily, a respectable lawyer, one who had any self-respect, would say, no, Mr. Trump, you can't exercise self-defense under those circumstances. In other words, you can't take another human life unless that person is posing an imminent threat, a serious risk of death or serious bodily injury to you at the moment you exercise, self-defense and take a human life. Most lawyers would decline to raise self-defense. Donald Trump has bullied or coerced or convinced his lawyers, just go in and make frivolous claims, like anything I take from the government when I leave is mine. It really is the defense that, if I take it, it's mine. And most lawyers would decline to make that argument in court. Donald Trump's lawyers have made it in court, just as Donald Trump has made it in the court of public opinion. And even Trump-appointed judge, Donald Trump's favorite judge, Aileen Cannon, even she will be duty-bound to reject that kind of a claim.
Well, Glenn, for posterity here, can you talk about why the Presidential Records Act was actually passed and why, for that reason, it would be especially insane if it meant that Trump could do what he's saying it allows him to do?
Yeah, it was passed in the aftermath of Watergate, right? Because Richard Nixon was trying to claim that the audio recorded conversations of him in the Oval Office, doing government business, making all of these presidential decisions, even though some of them turned out to be criminal, it was all his personal stuff. He should be allowed to keep it. He shouldn't have to divulge it, particularly not in response to a grand jury subpoena. So, that was clearly an abuse of governmental power that ultimately was addressed by, among other reforms, the Presidential Records Act, which says if they are presidential records, if they're records that belong to the federal government, then they must go from the federal government's possession to the National Archives, not from the Oval Office down to your, third-rate resort in Florida to do what you would like with them, store them in bathrooms and ballrooms and endanger our national security. Now, if these were diaries, if Donald Trump was sitting there kind of recording his own private thoughts during his time as president, okay, those might be private records that he could take and they wouldn't be subject to being turned over to the National Archives. But our national security documents are classified information, not private records.
It's just wild to me that he would invoke the very act that quite literally prevents him from doing what he's claiming that he can do right now, as if it offers him some justification. I mean, it is straight up like living in the upside down with this guy. Glenn, Jack Smith has been aggressive in his responses to Trump's absurd court claims like this one, but at the same time, he's been relatively passive in dealing with the judge overseeing this case, that's Aileen Cannon. Both Trump's team, for example, and Jack Smith himself recommended trial dates this summer. Judge Cannon herself seems intent on taking it upon herself to give Trump a delay anyway. Why do you imagine that Jack Smith won't try to just have her removed? There's already a basis to do so.
I almost feel like the time has passed. If Jack Smith was going to file a motion to recuse her, to have her removed from the case, I think he would have done it early on, because I think it's a matter of principle. When we have the very first prosecution in our nation's history of a president, I think a common sense rule and practice would be the judge who presides over that criminal prosecution of a former president should not owe his or her job, lifetime tenure on the federal bench, to the defendant over whose case the judge is presiding. I think that would have been the time, because the argument could have been made that just kind of as a policy matter, it has a real appearance problem. But even, in addition to that, you would couple that with the fact that the 11th Circuit Court of Appeals had previously reversed Judge Cannon for abusing her judicial discretion in favor of Donald Trump, doing something that the law did not allow. And in fact, the appellate court criticized her as having interfered in an ongoing Department of Justice investigation to Donald Trump's benefit. So I actually thought there was ample evidence to move to recuse her previously. I just think once you decline to do it at that point, you talk yourself into every other questionable ruling Judge Cannon makes as being not quite enough, not quite enough, not quite enough. But Brian, here's what I think we should all keep an eye on. If Judge Cannon sort of goes completely off the reservation and grants one of these wacky motions that Donald Trump's lawyers have offered up, particularly a motion to dismiss, because that would be a case terminating decision by the judge, and I'm almost certain that would be appealed. It would be appealed not only because the way she decided the motion was likely wrong, but I think then he would probably have enough in aggregate in combination with everything she has done to file that motion to recuse. So I think there's still an outside chance, but I think there would have to be one dramatic misstep by Judge Cannon in order to push Jack Smith over the line into finally filing that motion to recuse.
Well, just to game that out for a second, if, for example, she does grant Trump's motion to dismiss and the case is dismissed and Jack Smith appeals it, I know that the appeal system can be, we've spoken about the fact that the appellate court system is bogged down for, for years, for example. Does that mean that this case wouldn't even be appealed for then, for years?
No, ordinarily, the way the appellate court system bogs down is after a case has been tried, there's been a conviction, and the defendant has been sentenced, and an appeal is taken in the ordinary course of business. That gets thrown into the pile of appeals, and I will say, in the court's defense, the appellate courts are really overburdened. Their caseloads are enormous, and frankly, we could use more federal judges to alleviate that problem. But no, if it was a case-ending decision prior to the case being tried, like a motion to dismiss granted by Judge Cannon, that is something the 11th Circuit Court of Appeals could, and I predict would, take up and resolve very promptly, like perhaps within weeks.
And by the way, that I know, like, it would seem like going through the whole process of like watching Judge Cannon dismiss this case and then having to appeal it, that would take a long time. But frankly, she's granting him all these delays that he wants anyway. So that might actually be a quicker avenue than just waiting for her to like get this damn trial started already.
Brian, that's a great point, because at a recent hearing down in Florida, when Jack Smith proposed a July 8 trial date, and much to my surprise, Donald Trump's lawyers made a counter proposal of August 12th, which I actually thought was somewhat reasonable. What did Judge Cannon do? She said, I don't think Jack Smith's proposal is reasonable, and then by extension is 1 month later, August, all that reasonable? Well, that's the one Donald Trump said was fine with he and his lawyers, but she has yet to set a trial date. She's just kicking this can down the road. So it sure feels like she is determined to give Donald Trump, as much time as he wants or needs, or maybe even more than he needs, more than he has requested with his August 12th trial date request. And it just feels like she's determined to make sure this case doesn't go until after the election.
Yeah, well, look, Trump finally got one defense attorney who he doesn't have to pay by design, and that seems to be Judge Cannon. So with that said, we will obviously stay on top of any updates that come with this case, along with the rest of the prosecutions that Trump is contending with. So for those watching right now, if you haven't yet subscribed, please subscribe. The links to both of our channels are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.